reconvene the general session. Will the recording secretary please call the roll?
Kathleen Allevy, Kirsten Barnes, Catherine Williams Brown, C. Michael Cooney, Linda Darling Hammond, Marisol Escobedo, Jose Gonzalez, Makita Grinnell Shire, Johanna Harwick, Alicia Hine, Bonnie Clapp, Calvin Quinn, Jean Marks, Monica Martinez, Castle Redmond, Ade Rodriguez, Tina Sloan, Andrew Wall, Michelle Zuma. We have a quorum.
I now recess the general session and move to the Educator Preparation Committee. Commissioner Gonzalez, will you please reconvene the committee?
Good morning, buenos dias, bon dia, satsrikal. I now reconvene the Educator Preparation Committee. We have one remaining item. Item 3E is proposed amendments to Title V of the California Code of Regulations pertaining to cost recovery fees for extraordinary accreditation activities. This item is being presented by Catherine Polster and Terry Clark. This is an action item. Ms. Clark, can you please begin?
Yes, good morning, commissioners. Aren't the titles to the regulatory items fun? This item brings forward to you regulatory language that will implement policy decisions you've already made. The California Code of Regulations, Title V, is the place where requirements and fees are documented for the public. When you make policy decisions about things like the names of credentials, credential requirements, the accreditation fee structures, for example, those decisions actually don't get implemented until the Title V regulatory process has been completed. The topic of these specific regulations is accreditation fees. There are two distinct types of accreditation fees. Annual fees, which are for all regularly scheduled accreditation activities for all 260-ish institutions that are in your accreditation system, and extraordinary fees. These are fees for activities above and beyond regularly scheduled accreditation activities. A couple years ago, when the state was in recession and teachers were being laid off and enrollment in credential programs was historically low, credential revenues in this building were significantly down because this is a special fund agency. At that time, the legislature passed 2 state budgets in a row, putting in place these 2 types of fees. The 13-14 budget put in place the extraordinary, or what we also call the cost recovery fees. And in the 14-15 budget, the legislature created annual accreditation fees. In annual accreditation fees, all commission-approved institutions are invoiced on August 1st with the fee. It's due September 1st. And if the annual fee has not been received by October 31st, the institution's ability to submit credential recommendations is suspended until that annual fee has been received. But back to this specific regulatory packet. As part of your effort to streamline and strengthen the Commission's accreditation system, within that larger effort of streamlining and strengthening educator preparation as a whole in California, the accreditation system was significantly modified. One of the areas where a lot of the change took place was in relation to initial institutional approval. Prior to the process, this is the process where an institution, a college or a university, or a school district, county office of education, or a charter school requests approval from you as a body to offer educator preparation in California that leads to a license, a credential from this building. The process used to be 2 steps. The commission heard from the institution once, and it would give institutional approval. The entity went to the COA to review its programs. It was then operating. It was in the system. It had full approval, and nobody looked at it other than through regular accreditation activities. Now, though, the process is a 5-step process. Many of you will remember the green graphic with the 5 columns on it that comes before you when staff presents IIA items. This was an unusual meeting. We didn't have an initial institutional approval item. The first time the institution comes to you, they're looking for their eligibility. They've satisfied the eligibility criteria from staff's review, and then you review the final criteria. If you approve them at that stage, they're then eligible to propose programs. But the institution comes back in front of you for a review of both the preconditions and the common standards. Then, if they meet the standards there, the institution is only granted provisional approval. During provisional approval, the institution may offer a program, a couple programs that are closely related once the COA has approved those programs. But the institution will return to you again after hosting a focused site visit, where a team goes out and looks at the programs. The focus site visit takes place the year after the first set of completers finishes the programs. Data must be included about the assessments during the program and the candidates post-program, and that report comes to you. Now, you've not yet seen one of those reports. There actually are 6 institutions that have earned provisional approval, and the first one would come back to you in spring of 2020 after its focus site visit. That would be Turlock Unified School District. They proposed an induction program. They were kind of the first one through as we were doing this new II process. The report from that site visit, including all the data and the team's recommendations, will be brought to you for review, and your ability then is to grant full approval or to deny approval to an institution. So that process has changed significantly. As I mentioned at the beginning of this presentation, all the policy decisions and their corresponding fees have really been brought to you previously. So as a summary, these regulations address the IIA process, some cleanup for when institutions in the accreditation system are either late with a required submission, such as when their common standards are due or their preconditions are due and they don't meet a deadline. When an institution is required to do some follow-up due to an accreditation activity, so they have to have a revisit, they have to submit quarterly reports. And also there's a fee associated to national accreditation, CAPE, the Council for the Accreditation of Educator Preparation. They pass a fee on to the commission for the institutions they work with in California. This is an extraordinary fee because in California, national accreditation is voluntary. So a year ago, we brought you an item about moving this fee also into the extraordinary fee structure or cost recovery fee structure. Now that I've kind of set the stage for you, Ms. Polster is going to walk you through the regulatory specific parts of this packet.
Good morning, Commissioners. So now that we have some background, I'm going to go through the detail of the updates being proposed in the amendments. And in your agenda item, Table 1 provides the current fees and proposed changes. Table 2, spanning multiple pages, has a very detailed line-by-line rationale for each individual amendment, and that's what OAL really likes to see. And finally, Appendix A has the strike-through and underline version of the proposed regulations showing the changes from current to what is being proposed. So as the Commission strengthened and streamlined the accreditation system, terminology was updated. And one of the first changes that we made to the regulations was to bring the terminology current and replace the outdated terms like program assessment and biennial reports with the current terminology so that the regulations are clear regarding the types of accreditation documentation that are subject to cost recovery fees and when they're due. Additionally, the definitions in Section 80691 have been updated to remove all of the secondary sources of information or articles incorporated by reference, as what they call them at OAL, such as our accreditation handbook chapters. Instead, we've provided more detail as to the types of documents and site visits that the Commission's accreditation system process utilizes. The largest changes, as Terry's kind of gone through, were the fee structure changes for initial program review and initial institutional approval. For initial program review, the fees were previously based on the number of standards in a program, and since the standards have been streamlined and strengthened, the number of standards is no longer indicative of the complexity within the program or the efforts needed to review the program. We did not change the fees for IPR at all, only the categories. So now the category titles, I should say. So now the IPR fees are matched to the complexity of the program and the review process. And in the item, Table 3 provides you the 3 categories for IPR and where the programs fall within those categories. For initial institution approval, as you're very aware, we've had considerable process updates that required changes to our regulations. The previous process was a flat fee of $2,000, and now, because of the process being so much more rigorous and having additional staff time and multiple stages for documentation submission and decision points by the Commission, we've changed it to individual $1,000 fees for the review of eligibility requirements, Commission standard response review, precondition response review, and a per team member fee for the focus site visit at the end of the provisional approval period. So, in addition to IPR and IIA changes proposed, we're also proposing removing the in-kind option for initial program review, adding one new fee for joint site visits, and deleting one fee that's no longer relevant. When cost recovery fee structure was initially created, an in-kind payment process was created with the intent to ease the financial burden for IPR. Institutions had the option, they currently have the option of sending 2 BIR-trained faculty to the commission at the institution's cost to review documents in lieu of making the IPR payment for their own IPR proposal. The year after the statute allowing for cost recovery fees was enacted, the legislature passed an additional one for annual accreditation fees, and that statute expressly prohibited any kind of in-kind option for fee payment. So that, combined with the fact that the process just has not been utilized very much by institutions, led us to proposing elimination of the in-kind fee or the in-kind process for the regulations. As Terry mentioned, the new fee being proposed is the $2,500 joint visitation fee, which covers the cost of CAPE dues for joint site visits. Adding this fee into the cost recovery regulations was approved at the September 2017 meeting. And finally, since the iterative program assessment process has been replaced with program review, which now only requires a single review, the fee for program assessment beyond 3 rounds of review has been eliminated because it doesn't apply. So again, in the item, Appendix A has the proposed changes to the regulations in underline and strike through. Appendix B has our current regulations. Appendix C has the governing statutes for the proposed regulations, and Appendix D has the calculations for the determinations of the fees. If the Commission approves these regulations, staff will prepare a notice of proposed rulemaking to be published by the Office of Administrative Law and schedule a public hearing at a future Commission meeting. We'd be happy to answer any questions you have at this time.
Thank you. I don't see any public comment cards, so we'll open and close the public comment period. Commissioners, questions, comments? Commissioner Clapp?
This is just a comment. In a past life at CDE, I had to walk regulatory packages through this process and work with OAL. So I just want to say how much I appreciate. We see the tip of the iceberg of this work whenever we do regulations, and your presentation and all the materials you produced, as always. I mean, I think we take that for granted here, that staff does such a wonderful job on these. And I just want to recognize the huge amount of work that goes on behind the scenes for regulations. So thank you.
Commissioner Brown?
Yeah, it's just stunning in its detail. And I also particularly appreciated then when you had the cross-outs that I could then compare it. I appreciate that. I did have one question that isn't about the financing piece. I was just glancing at the categories for preliminary, second, and additional authorizations. And all the work that we did around Ed Specialist, I think we might need to rename mild, moderate, and moderate severe, but that's not about this topic. I just happened to notice that because I know we've done extensive conversations about that.
That is very true, but we can't rename them in this regulatory packet until the regulatory packet that renames them is done and complete, and then this regulatory packet will have to also be updated.
I knew it. Great, thank you.
Commissioner Sloan?
Thank you. I have a question on page 3E4 about changing the in-kind payment for initial program review. And I was just curious about how this was done before and why it's been eliminated.
I'll do the history part of where did it come from. The staff had not put in kind in the first regulatory packet, and at a commission meeting, I believe it was Chair Gahagan at the time said, and we were in a statewide recession, that there was a concern, and is there a way to reduce the stress on institutions? And what we came up with and what we put in the first set of regulations was that if an institution has sent 2 people to serve as reviewers, and these people have to already have been trained in the BIR. And so the institution sends them at their own cost to do a review, and they've done 2 reviews, then that could waive their new initial program review fee. This was not allowed to be done for initial institutional approval because the institution's not yet in the system. So it was only allowed for institutions already in the system. And it really ends up that the institution pays more most of the time to pay 2 people to travel to do the review process. And you have to have the 2 trained people, and then you have to keep track of it. And I know Ms. Polster has the actual total of how many times this has happened. 15 over the last number of years. And the amount of staff time to keep track of people's in-kind as it adds up to be able for an institution to redeem it has been pretty intense. And then on top of that, the next year when the authorizing legislation came through for annual fees, the language in the Ed Code did specifically prohibit in-kind, that you cannot do in-kind for this. So we are proposing that it be removed.
I knew there was a good reason. Thank you. One other question, and then going down to the next page on focused site visit. I'm guessing that the current and the proposed are the same because they both say 1,000 per team member. Okay, so it just didn't say the same. Okay. All right, thank you.
Any other questions or comments, commissioners? Okay, this is an action item. Do I have a motion to adopt the proposed amendments to sections 80691 and 80692 of Title V of the California Code of Regulations pertaining to the cost recovery fees for extraordinary accreditation activities, and direct staff to file a notice of proposed rulemaking with the Office of Administrative Law and schedule a public hearing for a future commission meeting? Commissioner Hartwig? Commissioner, what are you doing over there? Rodriguez? Commissioner Rodriguez. So we have a motion and a second. Any further discussion? All in favor? Opposed? Thank you. Same sign. Motion carried. Thank you, Ms. Clark. Ms. Polster. Having no additional items, I adjourn the Educator Preparation Committee.
Be efficient. Next is the Certification Committee. Commissioner Klatt, will you please convene the committee?
I won't be here long, I don't think. All right, good morning. I now call the September 2018 meeting of the Certification Committee to order. We have one agenda item. Item 4A, and this is, Terry brought up the length of the titles of these regulatory items, and I'll try to say this in one breath. Item 4A is proposed addition to Title V of the California Code of Regulations for the handling of applications, including variable term waiver applications, couldn't do it, submitted by qualified individuals with a disability. This is an action item that will be presented by Tammy Dugan. Ms. Dugan, will you now begin?
Thank you, and good morning, members of the Commission. And thank you, Terry Clark, for that background on OAL regs, or Title V regulations. At the June 2018 meeting, the Commission repealed the numerical limits for speech-language pathology services waivers that were established in 2014. The repeal of the numerical limits was due to an appeal from an individual with a qualified disability who argued that the waiver was a reasonable accommodation. Staff was also directed at the June 2018 meeting to propose regulations for the handling of waiver applications from qualified individuals with disabilities, propose regulations to establish numerical limits for all waivers, and provide information on progress of individuals serving on waivers. There. General information related to the purpose of variable term waivers, the requirements typically waived, and how waiver applications are evaluated are provided in the item. Table 1 in Appendix A provides the current practices for initial issuance and reissuance of variable term waivers. Tables 2 and 3 provide data for variable term waivers issued over the past 20 years. Proposed regulations to establish numerical limits for all waivers and detailed information on progress made by individuals serving on waivers will be presented at a future meeting. As you can see from the tables, it's a very involved issue with a lot of moving parts. So this item addresses the first staff directive to comply with the Commission's agreement to regulate requests for reasonable accommodation from qualified individuals with disabilities. The addition of Title V, Section 80002.1 is to clarify that applications from qualified individuals with disabilities who request a reasonable accommodation will be reviewed by staff in the Certification Division. Staff will determine whether an individual has submitted sufficient medical documentation to verify a mental disability, physical disability, or medical condition as defined in Government Code Section 12926, and whether the request for accommodation is reasonable. Staff recommends that the Commission approve the proposed addition of Section 80002.1 to Title V of the California Code of Regulations related to the handling of applications submitted by qualified individuals with disabilities for the purpose of beginning the rulemaking file and scheduling a public hearing. And I'm happy to answer any questions you may have.
All right, thank you, Ms. Dugan. We will now open for public comment. We have one public comment card. Rigel Massaro, can you please state your name and affiliation for the record?
Good morning, Commissioners. Rigel Massaro with Public Advocates. I just wanted to thank staff. I think I peppered them with questions back in June about this issue. It's something that I still feel like I'm very much learning about, and Appendix A is very helpful. There's a lot to digest for me. Very interesting, kind of seems like really the basic skills requirement. The CBEST is one of the primary reasons folks are needing these waivers and perhaps needing them on multiple occasions. And, very pleased to see that we have the vast majority are just asked for on a one-time basis. But I do appreciate also that this is the beginning of a broader conversation, certainly support the proposed regulations that issued today, and appreciate mention of the potential to regulate waiver limits in the future, and consider the different types of waivers, the different types of student populations we know are being served by individuals holding these waivers. So just wanted to appreciate these pages of data, I hope to be educated by other stakeholders about the story behind this data. It's something that I don't know much about. I'm sure that a lot of the stakeholders to this body can paint the picture as to why it is that these are occurring, and particularly on a multiple reissuance basis. So look forward to learning more, and thank you for helping me in the process.
Thank you. The public comment period for this item is now closed. Do commissioners have any questions or comments on this item? All right, since this is an action item, do I have a motion to approve the recommendation for the proposed addition of Section 80002.1 to Title V of the California Code of Regulations related to the handling of applications submitted by qualified applicants with disabilities for the purpose of beginning the rulemaking file for submission to the Office of Administrative Law and scheduling a public hearing? Okay, her hand was up, so I have a motion from Commissioner Barnes. Do I have a second from Commissioner Gonzalez? Any further discussion or questions on the motion? All right. All those in favor say aye. Opposed or abstentions? All right. Motion carries. Thank you, Ms. Dugan. This concludes the business before the Certification Committee. The committee is adjourned.
Great. Rolling right along. Next is the Professional Practice Committee. Commissioner Cooney, will you please convene the committee?
This is the Professional Practice Committee. Call to order. We have two items today, 5A and 5B. Both are for information only. The first is the workload report, the regular monthly workload report, and Mr. Gonzalez has that. Good morning.
Morning. Good morning, Commission. As stated, I'm Gil Gonzalez, Manager of the Division of Professional Practices, and I'll be presenting the Division Workload Report, which is informational item 5A. To increase its oversight of the Division of Professional Practices, in 2011, the Commission on Teacher Credentialing directed staff to present information about the DPP's workload as part of the Commission's agenda. The Commission's dashboard reports on 6 key measurements in line graph, shown both current and prior year numbers for comparison purposes. Some of the highlights. Total cases are the number of open cases within DPP, including cases in the intake unit, before the committee credentials, pending before the Commission, and administrative hearings. At the end of August, the caseload total was 2,789, which is within the new normal range of 26 to 2,800. The prior normal range was 24 to 2,600 cases. Cases open are new cases received during the month from all sources, including criminal arrest notices, district reports, affidavits, self-reported misconduct. Staff opened 521 cases, which is slightly above the normal range of 400 to 500 cases. As can be seen in the initial review graphs, the committee continues to effectively handle the larger number of cases under consideration, which we increased to approximately 100 per month earlier this year. The numbers in both the initial and formal graphs reflect the number of cases reviewed by the committee during its 3-day meetings. Cases closed in August were 435, and which were within the normal range of 400 to 500 cases. AG cases refer to cases in which an educator requests an administrative hearing to challenge a recommendation for discipline made by the commission or the committee. Sorry. An administrative hearing is an evidentiary proceeding where the administrative law judge hears and rules on the evidence. And the commission is represented by the Office of Attorney General. At the end of August, the case load was reduced to 179. I'd be happy to answer any questions.
I don't have any public comments on this item, so I'll ask if there are any commissioner questions. Not seeing any. Mr. Gonzalez, thank you very much. We'll go to item 5B, which is our annual report.
Thank you.
And I'm sure we'll stimulate some questions. Item 5B is the annual workload report, and the director of the division, Vanessa Whitnell, will present. Good morning.
Good morning. So nice to see you. I feel like I just saw you. We could have camped out. I'm happy to present this item to you, which will synthesize the workload for the 2017-18 fiscal year for the Division of Professional Practices. Just for new commissioners, the Division of Professional Practices prepares cases of educator misconduct for the Committee of Credentials. And this body, the commission, has the ability to discipline applicants or holders for fitness-related misconduct. And so, as you'll see in reviewing this annual report, the overall summary is that the workload for the Division of Professional Practices and the Committee of Credentials has increased substantially. But we continue to maintain timeliness. My plan is to just go through page by page and highlight the details for you, answer any questions as we go along or at the end. So turning to page 2 of the report, you can see the overall division workload. And as Mr. Gonzalez just shared with you, that workload actually began an uptick in 16-17. The prior average for cases opened on a monthly basis was 2,400 to 2,600, And in 16-17, that crept up to 26 to 2,800. What you can see for this fiscal year report, which is 17-18, the range was 2,700 to 2,962 open cases per month. So we can see a substantial increase in cases over the last 2 fiscal years. Going down to the next graph, or table at the bottom of page 2, it says new cases opened by report type. And where are all these new cases coming from? What we can see from this report is they are primarily coming from applications from individuals with a criminal record history. And perhaps in part, this may be due to the significant publicity surrounding the teacher shortage. You're probably, we know that there is a huge uptick in applications. Our division is responsible for ensuring that those people are screened carefully. So our workload has increased primarily due to applications by individuals with a criminal record history. And that's the piece that says application and wrap. You can see that in 13-14, that number was 1,811. And in 17-18, it's 2,538. So it's a pretty significant increase. Turning over to page 3, there are 2 other trends that I'm seeing by this graph, or tables, excuse me. They're not as significant as the applications with rap sheets, but they are school district cases. And prior to the 2011 audit, school district cases only made up 3% of the misconduct workload. And there were some very highly publicized cases, I'm sure you recall Miramonte, that encouraged superintendents to report to us. So we see an uptick in school district cases, which now makes up 13% of our workload as opposed to 3% of the workload. The other trend that I'm seeing here is that affidavit cases have risen by 53%. That's very significant, and that's since 14-15. One of the possibilities for that is that we have our brand new website, which is very helpful and informative. On that website are ways for the public to report. So we have our affidavit forms and the instructions for how any member of the public can fill out a form and report misconduct. And so in credit to our ETSS staff and our staff who works in conjunction with them, we have really made some significant upgrades to the website, and that may be why the affidavit cases have increased so significantly. So I'm still on page 3, and I am at new cases opened by designation, which is the table at the bottom. And as you can see from this table, the total annual number of cases in 13-14 for our division was 5,514. For this last fiscal year, it was 5,895. So there is an increase monthly of open cases of about 430, and annually about 300 overall. I think if you look at the first-time applicants designation, you'll see that in 13-14, there were about 1,900, and this year there were 2,384 first-time applicants with misconduct being processed in our unit. So again, the stimulus that you're putting out there to encourage teacher applications is also having a parallel effect in our division. So as compared to 13-14, the number of applicant cases has increased by 250. The number of applicant holder cases, which are probably renewals and reissuances, that has increased by 75 this year, and the number of first-time applicant cases has increased by 431. So that should give you an indication of where the workload has increased in our unit and also for the Committee of Credentials. I'm going to move over to page 4 and discuss the Committee of Credentials workload. Prior to the 2011 audit, as you've heard many times, the committee reviewed approximately 45 to 50 cases at initial review, and that's every month during their 3-day meeting. And then after the audit, the committee was reviewing on average of 90 cases at initial review per month. This year's average for 17-18 was 95 cases per month. And now the committee is currently hearing 105 cases per month. And that is at initial review only. So initial review is that initial screening phase where the committee determines whether the case will move to formal review. So you can see that due to our new normal caseload, that's what we're calling it, the committee is now being quite strained in the number of cases that they are hearing. We'll move over to page 5. At the top, there's a table that says formal review cases. And what I would want to emphasize from this is the committee does not just hear 105 cases. That is initial review. Then they determine which of those cases is going to move to the formal review process. And you can see if you look at the 17-18 year for formal review, you're looking at about 70 so odd cases per month go to formal review. And that was of the average 95 cases they were hearing at initial. So of the 95 or so, approximately 70 were moving to formal. So maybe 25 or so were closed at initial review for some type of legal reason. Or the conduct is not related to their fitness to teach. So at formal review, that's a very long process because the individual has an opportunity to appear with counsel. Imagine if 74 people showed up for a 3-day meeting with their attorneys. Right now, we're averaging about 25 to 30 appearances per month. So only about half to a third of these people actually are choosing to come with counsel. If we had where all 74 people were asking to appear, I can't imagine the committee could sustain that workload. So they have initial review, they have their formal review workload, and then in that next table you can see consent calendar cases. The consent calendar is kind of like your consent calendar where it's there, they can pull it off and say, no, we're not going to close this one, we want to go forward, and we want to send a letter of inquiry. Their consent calendar total number for 17-18 was 1,566 items. So that's how many cases per month, or excuse me, per year they're reviewing on consent of misconduct. So it isn't just their 105 initial review and their formal review. They also have to look at these consent calendar cases to determine whether to go forward. Very, very large workload for the committee. So I want to move down. I'm still on page 5, where it says how many cases were closed by the commission's delegation to staff. And if you recall, in years past, after the audit, Nanette Rufo, who previously was in this position, was trying to find ways to streamline for efficiency. And one of the things that she did was she brought an item to you to create a staff delegation to close certain types of misconduct cases. And these tables on 5 and 6 show you how many cases the staff has reviewed without the committee and closed before committee review. So that's another part of our workload. So single alcohol offenses is the first table that we would be looking at, and that's at the bottom of page 5. The commission adopted a policy that allowed staff to close on a single alcohol-related offense, so long as it doesn't involve children or schools, that there's no nexus. So the staff closed 1,402 of those cases after staff review this year for 17-18. If you look over on page 6, the no jurisdiction for formal review was a delegation where if we do not have what we call D jurisdiction, we cannot go forward. Technically, those could still go to initial review, but rather than do that, you delegated to staff to close those, and the staff closed 726 of those for that fiscal year. Below that is the vehicle code violations. The commission delegated to staff to close certain specific vehicle code violations like infractions, any that are not involving children, schools, no nexus. After review of all of those cases, the staff closed 82 of those. So all of these are saving the Committee of Credentials from seeing these cases, and they likely would not result in any action. And that's what you had identified in those delegations. And then the last one is expired credentials. At that table, you can see that the staff closed 157 cases based on that policy. Your expired credential policy means essentially that you have delegated to staff to close reports of misconduct if the person's credential is expired. You made exceptions to that policy. What that does is the person has no license to teach. So if they reapply, we still review the misconduct. There is no statute of limitations on an applicant. So it isn't as though they can just apply and be granted. It just means we're not looking at that case now because they can't be in the classroom anyway. You made some exceptions to that policy, and they're listed here. Allegations of sexual misconduct, crimes against children, reports filed by school districts, and actions taken by other licensing agencies. The reason that you did that is because even if the credential is expired, that person can go to another state and apply for a license. And so you asked us to continue to go forward on those types of cases so that it could result in an action and be reported to NASDAQ and protect children in other states. So we can't close everything on an expired credential, but the staff did resolve 157 cases. And as I said, if they reapply, we would still be reviewing that misconduct. On page 7 now, this is the wonderful news, despite the very large increase in workload that I've been talking about. The wonderful news is that we have continued to ensure timeliness, despite the significant workload increases. If you look at this table, it's a testament to the dedication of our staff, truly. The educator discipline timeliness table compares where we were at the time of the audit in 2011 to where we currently are in timeliness. So if you look at the first part, receiving a report of misconduct, at the time of the 2011 Bureau of State Audits report, it took an average of 128 days to open a file. It now takes 14 days to open a case in our unit. And that's not us just sitting there, I'll get to it tomorrow. It goes through a statute of limitations review during that time by the attorneys. It goes through a jurisdictional review. It has to be labeled. The case has to be open. Things have to be gathered. So 14 days for that type of processing is really impressive. If you look at the next piece, once a case is opened, before staff would start collecting documents, it was taking 103 days at the time of the audit. It now takes 14 days. And as I said, that is not just it sitting there, it's going through a process of review by the attorneys, of determining whether this is a case that can go on the consent calendar as opposed to one that needs to be investigated, etc. Moving down to this next category where it says DPP requests, court and law enforcement and other documents. At the time of the audit, that was taking 274 days. It still takes approximately 185 days for that process because we have no control over it. So our staff will send a request to law enforcement or courts and hear nothing. And then we send a follow-up, and then we ask again. And so we don't control whether courts or law enforcement agencies are responsive or providing those, but we do the staff calendar, every week. I'm going to check back in with them and see if they're sending it to us. We also have an administrative subpoena capacity that we can operate in on some cases. So this is a piece that I don't think is ever going to get lower than 180 because the courts are clogged, law enforcement agencies are very busy with their own criminal cases, and this is an administrative process. So I think this is the best that we're going to be able to achieve because we just don't control it. The next 3 sections, letter of inquiry, formal review, and COC recommend, you can see those look the same as at the time of the audit. And that's because those are statutorily defined. So those can never be changed because they are set by statute. So you can see at the time of the audit, the average time that it would take to open a case and then for you to take your final action was 683 days, and it is currently 383 days. So it's approximately 1 year of process. So I'll move to page 8, and the tables there are mandatory and discretionary actions. I think I've shared with you, and I'll just repeat myself, that mandatory actions are defined by statute. The legislature has determined that certain crimes make an individual unfit to be in the classroom with children. And those are not cases that you see. Those are cases that are an operation of law, that the staff collect documents and they must be processed, and they're a ministerial action by Dr. Sandy. And so those, we processed 207 mandatory actions for the 17-18 fiscal year. And discretionary, the table below that, 687. Those are the actions that you took. Your final actions on discipline were 687 for the 17-18 fiscal year. If you look at the number of adverse actions, it's fairly consistent in ratio relative to prior years. Even though our workload is significantly increasing, the ratio of adverse actions remains consistent with prior years because you're still looking at the same nexus to fitness. If you turn over to page 9, we can talk about the Attorney General's workload and other good news, which is despite our increasing workload, the Office of the Attorney General's workload on our cases has shown a decline. If you see the high of 307 in fiscal year 16-17, at the end of 17-18, the cases pending with the AG were 201. And as you heard Mr. Gonzalez mention, they're now 179. So we're actually very, very close to equilibrium. And I know that we've all heard over and over in past years, when is the AG going to clear those cases out? We've now reached that place where we're almost there. The AG adjudicates these cases in many ways, and this affects your closed session calendar, as you were feeling last night. So if you look at administrative adjudicative workload, in that table, that second table on page 9, this is telling you what you're going to see in closed session. Why are you there so long, and what are you reviewing? We categorize these. These labels are what our system calls these things. So the AG does their own report, and they may call them something different than we do. But here you can see, how does the AG resolve a case? How did they do it for 17-18? And why did this impact your closed session workload? The decline to prosecutes is the first category. You don't see those. That is when we send a case over to the AG and they decline it. And that means we have no control over it and it is closed. They decline for, in the interest of justice, because of insufficient evidence. So it's them telling the Committee of Credentials, you don't have enough and you can't prosecute this case. And there were only 7 of those for the 17-18 fiscal year. Consent determinations, it looks like this table cut off, but that did say or settlements. You see those on your consent calendar. So there were 74 of those this year that you had to review for 17-18. And those were cases that the attorneys between us and the AG's office identified as proper for settlement, either due to staleness of evidence or witness issues, or we weren't going to be able to prove what was alleged to the committee. So there were 74 of those. Deceased, we had 2 people that their cases were closed. And proposed ALJ decisions, you heard many of those last night. There were 53 of those that you heard in 17-18. And that is when the AG gets all the way through hearing, actually takes the case and puts on the evidence. They actually did 53 of those in 17-18, which is substantially higher than anything that you had seen before. And that's why your closed session calendar is so huge. And again, you may reject those and call for the transcript and then go through your own process. So every single one of those lends itself to more time in closed session. Withdraw from administrative hearing. One of the things we noticed happening this year is that people started to withdraw their appeals because they see that the AG and the CTC are taking this process very seriously, and that we're either going to go to hearing or we're going to negotiate a very good settlement, and that we're committed to clearing these numbers out for public safety. So we saw a number of withdrawals, people that said, I don't want to appeal. And part of that may be due to the public process. When you go to an administrative hearing, the process is public. The transcript is public. Those kids and the things they're saying about you become public. So we noticed that trend. 6 of the cases were withdraw the statement of issues or accusation, and that is something only Mary can do. And that would be at the advisement of myself and the Office of the Attorney General to say, we investigated this further after the Committee of Credentials, and this didn't happen. We need to withdraw this. And so Mary Sandy did that on 6 cases, and 1 was recalled, and that's the last one, because the person was convicted of a mandatory offense, like mid-hearing, mid-process. So the decrease that you can see in these cases is in great part due to the streamlining that CTC and OAG have done together. When Linda Schneider and I first took this process over, we created templates, procedures, to really streamline everything that was happening into as many boxes as we could, and so that both our staff and her staff would be on the same page in terms of processing. So that was the first step. The other thing that we can say that led to the decrease in these numbers was our investigative unit. We've been staffed up to assist the Office of the Attorney General in investigating cases, to assist them in preparing for hearing. And our investigative staff completed 134 investigative requests for the AG's office this year. And also, and thanks in large part to Katie Hampton, who you all know, she is our liaison attorney to the Attorney General's office. And that relationship of communication with the DAGs has really increased the efficiency of our operating with that office. So I think last page is page 10, and at the top that table is petitions for reinstatement, and that's your other piece of your closed session workload. You can see that you heard 35 petitions for reinstatement in 17-18. You granted 18, you denied 17 of them, and those appearances take an awful lot of time. So you went from in 11-12, 22 petitions, and now you heard 35. So even that has increased your closed session workload. So to summarize, for the fiscal year 17-18, our caseload average has become what we're calling our new normal of 2,800 to 2,900 cases, as opposed to 2,400 to 2,600 cases. And our annual caseload has become a new normal for us, from 5,500 to almost 6,000 cases. And again, due to the increased numbers, the Committee of Credentials, rather than hearing the 45 pre-audit or the 90 post-audit, is now going up to 105 cases in addition to the other workload. And the Office of the Attorney General, as I said, has demonstrated decline almost to equilibrium on the cases that would be going to hearing. And despite the ever-increasing workload, I have to take a moment to thank our staff. The techs, the analysts, the investigators, the attorneys, our legal analysts, our managers, is a testament to our staff and the commitment to this work. and they are all hands on deck, managing something at max capacity right now. And so I would just take this moment, please, to thank our staff. And with that, I'm happy to answer questions.
Well, thank you very much, Ms. Whitnell. This is the most thorough and best explained annual report that I've heard in my time on the commission, and it has lots and lots of good data in it. You didn't mention Mr. Gonzalez's role in accumulating,
yes,
preparing this data, but you've told me about it. And
yes,
when I suggested that we might like to get this quarterly, I got a great silent answer. So, but it does point out not only the incredible amount of work done in the parts of the system in which we're involved, such as the committee's work and how that's increasing. And these 7 individuals have a workload every single month that is significantly more than the commission is faced with on its bi-monthly review. So all parts of the system are working at full speed and above, and there's a legitimate question as to how long that can go on. We have a limited role in being able to add to our staffing in any of the critical areas that you've mentioned, and I think publicly we should throw our support behind you and Mary and the rest of our staff in making sure that we have the resources to keep up with the workload, because we have no more important duty as commissioners than to take these cases and as quickly as possible move them through the system. Any questions from commissioners? Commissioner Hartwig.
Well, I just wanted to echo Commissioner Cooney's compliments for what a very well put together report this is, and echo your thanks to the staff. I'm new to the commission, but I've gotten a little bit of background on the audit and the crisis that was being faced by the commission at that time, and this is a truly amazing turnaround. And I feel like the commission and the professional staff can feel very confident that they are protecting the rights of the individuals who are coming before the commission while improving efficiency. I did want to ask I understand from the conclusion of the report that you are currently talking about potential staffing solutions, and I understand that the commission does not have much control over this, but I would be interested in a few comments from you about plans or thoughts you have about how to keep this sustainable for our staff whom we want to retain. And having worked in many busy situations, I know that retention under incredible pressure like this can be difficult, and we want to hold on to our excellent staff. And also how to make sure that the committee is able to keep up with its workload, given that there is a limit to which we can ask people to do more with the same amount of resources.
Well, I thank you for pointing that out, and you're very right. We have already lost some staff. We had an investigator leave for another agency, and it is a result of the workload that you're seeing, and burnout happens. And we are very close to that place. That's why I have to say, our staff is rare in the sense that they are wedded to this work. They love this work. They've left for other agencies and returned because this is the work that they are married to. And I feel the same way about the work. But you are right. There is only so many hours in a day. So we are in discussions with the administration and Department of Finance, LAO, with the AG. Mary Sandy and I have had a number of meetings and are taking this very seriously, putting this message out there in a public way, and both with the powers that be to ask for help. And we are sending that message, and we can only see in upcoming budget hearings where that will take us. So we are getting the message out there, and we are advocating for our staff, and we are advocating for the public safety and the due process of our educators. And we will keep you posted and informed if we get any traction or have more information for you. But we're really early in that process right now.
Commissioner Klatt.
Just to add some support to that publicly, I was looking at the table. It's on page 5B4 that shows the types of misconduct, and looking particularly at the crimes of sexual nature, and just imagining, there's been an uptick in the last year of that, but imagining the current climate in our country, and particularly the last 2 days, that we might see some increased numbers of reporting of these types of crimes. And so a concern is that if we're operating at the maximum capacity right now, if we do anticipate an uptick in those kinds of cases, where will we find the resources to adequately handle them? And that's a concern. And that, just as a general, and I have a teenage daughter, and in listening to conversations of, her classmates, the climate at our school, at our schools, that we're all kind of just remembering the responsibility to maintain. And I think at this table we're well aware of that because of the cases we see, but that students and adults feel like they can report these crimes, but that might also result in this increased number that we see coming. And so I'm concerned about staff's ability, because we know you're working so hard, and how will how can you work harder than you already are if you're already working at 100%? So.
I agree. I'm concerned too. And I tell the staff every day, thank you, and please hang in there. And I think we've created every efficiency possible. I can attest to that. And I can't attribute that to myself. I think Nanette Rufo and Michael Barth did that prior to my time. And what I'm dealing with now is an increase in application workload, and an increase in fingerprints, and an increase in criminal reports, and all of the things that we are seeing, and also having to help the AG. And, there's been the proposal of a new mandate on us to prepare these cases to clear and convincing in every case for the AG, which we are not staffed for. So my role in taking over Nanette's role is to ensure quality control in an increasingly stressful environment, and to support our staff. So I understand that, and I agree with you. And we are taking this very seriously and asking for help. And I don't know if Dr. Sandy has some words here.
Ditto. It is significant, and it's not just in our Division of Professional Practices. I mean, the increases we're seeing in professional practices parallel increases we're seeing in certification. We're seeing increased numbers of candidates enrolling in teacher preparation. We're stimulating growth in the teaching population with a series of grants. We're going to see increases, and there will be a concomitant increase across the board in every area. So as Council indicated, we are working with the administration on a plan to address this. There is a point at which the staff is working as hard and as fast as it can, and if the numbers exceed what we can do to keep equilibrium, then the result will be, if there are no new resources, that it takes longer to move these cases. And that's just a fact, and nobody wants to see that. I think our whole policy community is invested in this work moving as quickly as it possibly can, for due process for educators and for the protection of children. So we did have a bill that moved through the legislature this year seeking some relief for the committee on credentials, and that bill was signed, and it allows us to bring substitutes who are former members of the committee in to serve in the cases of absence, so that we always have a quorum and we have enough hands around the table to manage the work. There have been other ideas suggested in the past about perhaps creating a second committee, which is a way of easing some of the pressure on the body that deliberates for us, but it doesn't necessarily alleviate. It may, in fact, increase the amount of work for staff and create other kinds of complexities. But we are in the process right now of engaging, and have been for some time, engaging in the conversation across the board with how can we take this from an unmanageable workload and make it a manageable workload. And we're cautiously optimistic. I think there's unanimous support for the work of this agency being doable and effective. And so we will keep you posted. We do have a group of people here, and all of you spent hours at this last night, deep in our closed session. You understand what's at stake, and the commitment of Vanessa Whitnell and the staff over there it's almost to the level of, if not us, who, right? We have to be here monitoring this work. And that level of commitment is extraordinary. But it's not just in DPP, it's across the agency. We have a deeply committed staff, and we have more longevity, I think, in the numbers, the staff who have been here a number of years, who've made their career choices to be here and do this work, than many other agencies. We don't see the kind of churn and turnover that other agencies do. And there are, a number of reasons for that. So we're working on it. The news is good. In many ways, we're getting more teachers, more people interested in this work, and deeply so. And that's a really important, good thing that's underway. And we just need to catch up in terms of the resources it takes for us to manage that process well. And we are working on it.
Commissioner Sloan.
I wanted to two things. One, commend you on the clarity of the report, which reflects the clarity that all of your staff have and communicate on a continuous basis. These cases are so complex, and most people don't know what happens in closed session, but when you and your staff present to us, you're able to do so in a way that makes it where we can understand all of the issues. And the second point to that is we can understand all of the issues, and you communicate it so well because you know it so well. So despite all of the workload and the ways it's increased, I'm continually amazed at how many details all of you know about every single case. Every question we ask you, you dig deep into the paperwork and you find what it is that we're asking, and you help clarify things for us so that we can make the best decisions that we can make. It's truly impressive, and I just wanted to be sure that others knew that it's not just the breadth of the work that you are handling well, it's the depth that's so impressive. So thank you.
Thank you very much, and thank all of you for hanging in there last night with us. I know it's really hard on you, and it's a long night, and these are important decisions that you make. These are people's livelihoods and also the safety of children. We're here because we care about those things, and we don't go home until the work is done, and it means a lot to us that this is valued by the Commission and appreciated by the Commission, and that you hang in there with us even on those long nights. So thank you. Thank you all very much.
Commissioner Hartwig.
I just did want to ask actually just one more follow-up about some of the results, just to educate me a little bit about the final resolutions of the matters. When we're looking at so I'm interested in learning, have there been any changes in trends in terms of final resolutions of the matters as we've had an increase in the number of cases? Mm-hmm. And you mentioned one or two comments about this, I think, prior, but is there anything that you can detect in terms of trends in the way that the Commission is handling its discretionary actions for resolutions? The only things I notice are an increase in denials, I guess, in the petitions for reinstatement, but I think you've said that maybe there are more petitions as well, and a decrease in suspensions. Is there anything else that you can tell us about our own decision making that is illuminating for us?
I think your own decision making has remained fairly consistent in proportion to the number of cases. So if you're seeing this many more and there are this many more adverse actions, the proportions look the same to me. So I think your analysis as to fitness has not changed too much, that you are applying the factors in the same way. It's just that the caseload volume has increased, so you do have more petitions and you do have more ALJ proposed decisions to review, which leads to more reconsideration reviews in closed session. So, but in terms of your own actions, I think the actions of the commission have been fairly consistent in terms of the analysis of Morrison, and I don't see any change in terms of this commission being more conservative or more liberal and disciplined than any other commission. So that looks pretty similar to me relative to the ratios.
Thank you.
Anything else? Well, this started as a detailed and crucial report that we really appreciate receiving, and the inevitable conclusion we draw from this is we have a very capable and dedicated staff to work with, and I think the least we can do is stay a few extra hours if it takes that to hear all the cases you bring to us. So as the need arises, we're ready to help and look forward to our next meeting. Anything else from commissioners? Okay, then I will adjourn the meeting of the Professional Practices Committee.
Okay, thank you so much. Next is the Legislative Committee, and Commissioner Hind is absent today, so Commissioner De La Torre Escobedo is going to give that report. Thank you.
I now convene the September 2018 meeting of the Legislative Committee. The committee has one item before it today. Item 6A is status of legislation. This is an information item. Joshua Speaks will present this item. Mr. Speaks, please begin.
Good morning, Commissioners. So as you're all aware, the legislative session is over at this point. The governor has until the end of this month, so what's that, another day or two, to sign or veto legislation. If the governor does nothing with a piece of legislation at the end of session like this, then it passes into law without his signature. Fortunately, he's acted on all of the legislation that the commission is interested in, so we don't have to worry about any of that uncertainty at this point. The ledge item today is pretty short because at this point most things have either fallen by the wayside or already been dealt with. So I just have a couple of items for you today, and then I'm of course happy to answer any questions you may have. So with that, we had two sponsored bills this year, and as you know, one of them ended up being held in suspense, but the other, SB 1383, was signed by the governor on September 11th. Executive Director Sandy stole a little bit of my thunder with the last item because that is the bill that we're hoping will help the Committee of Credentials with some of their work. It, among other things, it removes some restrictions on recruiting school board and public members, so it opens up that pool a little bit. Anecdotally, I've been told that we have a lot of trouble, especially with that school board member position, because you've got such a small pool of folks to select from in the first place. So anything we can do to help with that recruitment is beneficial. And then it also, as Executive Director Sandy said, it creates a substitute list so that we won't have quite so many quorum struggles with the committee. If we have multiple qualified candidates for a position, we, or I shouldn't say qualified candidate, folks who have previously served on the committee, but just can't make that work full time anymore, they can still make themselves available to the committee as substitutes, so that if we have a meeting where the quorum is in jeopardy or they just need extra bodies to help them review all the material, they can call on those people for individual meetings. And so we're hoping that will ease some of that strain on the committee. Other bills of note that I wanted to point out, AB 2285 by Assemblymember O'Donnell. And, as we all know, the commission is always looking for ways to improve the teacher supply without doing anything to jeopardize our standards. And so with that in mind, there were some conversations earlier this year with the Assembly Ed Committee that resulted in this bill. And it made a couple of small changes, nothing significant, to help us clear the way for out-of-state teachers, making their path into California a little bit easier. So that was also signed by the governor and will take effect. Then we had a bill that sort of came up at the last minute, and it ended up being vetoed. But I wanted to highlight it anyway, and I'll explain why. AB 2547 was a bill by Assemblymember McCarty, and it related to the grant programs that were included in the Budget Act this year. Assemblymember McCarty, his bill would have taken the two new grant programs, the Teacher Residency Program and the Local Solutions Program, and essentially added more detailed reporting requirements. The budget language came with some sort of bare bones reporting requirements, but this would have added some interim reporting and then a final report and fleshed out some of the details of that. And the governor ended up vetoing it. In his veto message, he said that he felt that the reporting requirements in the budget language were sufficient. But the reason I wanted to highlight this is because I think it illustrates the fact that there really has, over the last few years, been a growing interest in the work of the commission and in what the commission is doing around the teacher supply. And I think the fact that even though the governor didn't necessarily agree with them, the fact that the legislature felt very strongly that they wanted more information, more detail about the way these grant programs were working and that sort of thing, I think that that's a significant indicator. And I wouldn't be surprised if we see something like this bill turn up again next session to try again with the new governor, because obviously these grant programs will take a lot of time to implement and to run their course, and so there's still plenty of time to add those additional reporting requirements. And so I wouldn't be surprised if we see something like this turn up again next year. So I just wanted to share it, even though it didn't actually get passed. And then I believe the last piece of legislation I wanted to highlight was SB 577 by Senator Dodd. And we've discussed this bill a few times. This is the bill that would, essentially it's looking to leverage our community college assets in helping with our teacher supply issues in California. And so the bill changed quite a few times over the course of the session. But what it ended up with was legislation that would authorize the commission to award up to 3 grants of up to $500,000 each to collaboratives that are made up of an accredited 4-year college that offers teacher credentialing coursework, and a community college or group of community colleges who can help facilitate that 4-year institution granting degrees and offering coursework and things like that in more remote locations. So this bill is really, the intent behind it is how do we get teacher credentialing programs out there to folks who aren't necessarily geographically close to a 4-year institution. Now, the bill passed. However, the bill did not contain any funding in it. So what it does is it authorizes the commission to award these grants, but there's no money for the grants at this point. So there's nothing that the commission will be doing immediately upon this bill, but it's something that we may see that grant funding show up in next year's budget. So I just wanted to make you aware of that. And with that, I'm happy to answer any questions.
Okay. Thank you, Mr. Speaks. We will now open for public comment. We have one public comment card, Rigel Massaro. If you can please state your name and affiliation for the record.
Good morning, Rigel Massaro with Public Advocates. I think I've been absent the past couple meetings when Josh has discussed legislation. I just wanted to extend my gratitude to Josh Speaks and Roxanne Perdue, Aaron Scooble, and Aaron Henderson for their tremendous work on AB 3048. There were a lot of stakeholder conversations, and is a really thorny issue with a lot of different tentacles into other issue areas that we had to kind of consider and work through. And I'm very supportive of them taking all that intelligence and relationship building and bringing that idea back in the future. And I also wanted to express my appreciation for the Commission with the work it's done very quickly and effectively to implement the RFPs on the teacher residency proposals and the local solutions grants. The video that Terry Clark and Council sent out was very helpful to the field. The questions, everything has, I think, been really punctual and informative, and I just recognize that I saw the posting for the new position in this area. This is an area of growth, and I'm excited to see the Commission rise to the occasion and bring the incredible staffing and detail that it has to this really important work around shortage. It's an area you've heard me talk about repeatedly, and really seems like the Commission now has real implementation work to do in this area, and I'm excited to see it happen and collaborate where possible. Thank you.
Okay. The public comment period for this item is now closed. Commissioners, do you have any questions or comments on this item? Commissioner Sloan?
I do. All of these sound are interesting, and I would love to sort of know where they stand and what you think is going to happen with some of them. So one is, and forgive me, I wasn't here last time, so AB 3149, the substitute teachers' days of service. I see the notes says the sponsor expressed their intent to not pursue it, but rather to work with the Commission through the stakeholder process. Could you tell me a little bit more about that?
Sure. So that bill would have essentially what they were looking at is, we have the new TPSL permit, which allows a person to serve in a class for the remainder of the period of statutory leave, that the teacher of record is out on. So, for example, if I have to go out with a medical issue or something like that, instead of either finding a new teacher of record or, rotating a series of 30-day subs through the classroom, a TPSL holder can fill the remainder of that period of illness, even if I'm out for 4 or 5 months.
Right.
The concern that they had that motivated this bill is that the TPSL does require a certain amount of training in advance. And so, there were a few different concerns. There were some leave types that were identified that the initial TPSL regulations didn't cover. For one example is military service, if you're a reservist who's called to active duty. But the main concern was, okay, so what if, Josh breaks his leg and he tells his principal he's going to be out for 2 weeks. And so we put a 30-day sub in the classroom who's not qualified for a TPSL permit. Well, then 2 weeks turns into 3 weeks, and then 3 weeks turns into, I'm actually going to need some pretty extensive physical therapy. I'm going to be out for a few months. And if the principal doesn't know about that in sufficient time, they may have all the goodwill in the world to get that 30-day sub qualified for a TPSL permit, but they may not have time, before their 30-day period in the classroom ends, or 20 days in the case of special ed. And so they were looking for ways around sort of implementation issues like that. And we had some pretty productive discussions. And when the bill was ultimately sort of amended so that it was just instructing the Commission to go study this problem and come up with some solutions. And at that point, the stakeholders said, well, if that's what the bill is going to do, then we don't really need a bill to do that, because the Commission plays very well with its stakeholders. And so if you can just commit to us that the Commission will look at this problem and we'll have meetings with the stakeholders and so on and so forth and look for regulatory solutions, then we're satisfied with that. We don't need legislation telling the Commission to do that. And so that's where we are. And so we've had some subsequent meetings with them. And I know that certification division staff have been, when they go out and do their public meetings and things like that, they've been trying to get some broad stakeholder input. And so that's where we are in that process.
Great, thanks. And then I'm also wondering about the bits of fees. Where is that one? AB 410? And then also, I guess, somewhat related would be the personal income tax deductions.
Well, so the induction fees, we've seen this particular bill in a couple of different iterations. I think it was Assemblymember Bonilla who did it 2 years ago, and then of course Assemblymember Cervantes introduced it again in 2017. The concern over this seems to stem from a couple different places. One concern is that if you don't allow programs to charge fees, some programs will just shut down. The other concern is that if you mandate that you can't charge a fee, then existing programs who are already not charging fees will come back to the state and say, well, I know we were already doing this, but now that you've told us we have to do it this way, it's become an unfunded mandate, and so you need to reimburse us for it. And so the concerns around that have primarily been around those fiscal impacts and the potential supply impacts if programs were to shut down. So it is still definitely a live conversation, and we've tried to be helpful from a technical perspective in that conversation. The Commission hasn't taken a position on the bill, but we've tried to be helpful when folks are having those discussions. But those are sort of where the main concerns lie, is just around that potential fiscal impact, especially if it were to be judged an unfunded mandate. Then as far as the personal income tax deduction bill, again, the concerns with that are primarily just around the fiscal impact, because the way the bill started out, it was much broader. And again, this was another bill that has been attempted before. I believe it was Assemblymember Holden before Senator Portantino tried it. And the idea is just that that those tax deductions would end up being relatively costly. So it's not as if the state has not been spending money on the teacher supply recently. I mean, we've seen all these grant programs. I think there's just a little bit more hesitance under this governor around programs that would be ongoing costs, as opposed to these grant programs where we can say, here is the pot of money. Once the pot of money is expended, it's gone. There's been a little bit more hesitancy around these sort of open-ended impacts. I would guess that there will be a little bit more willingness to entertain those sorts of things under the next governor, but that's speculation on my part at this point.
Great. Thank you so much.
Commissioner Clapp?
I have a question or maybe a comment about AB 3048, 3048, the teacher monitoring bill. Mm-hmm. And I know it's on suspense, and so it's kind of, maybe this is a moot point at this juncture, but it looked like there were some amendments to the bill to address the charter school issue and putting some of that responsibility into the authority. And there's, I noticed new language in that mm-hmm. around the charter school issue. So I don't know how much this agency had to do with some of that language, but I appreciate the language and the attention to that issue, because I think it strikes a balance between the need to report and the unique situations of some charter schools in reporting that. So I don't know if you have anything to add to that. I know it's on suspense, so maybe it's something for a later date if it comes back, but I wondered if you could speak to that a little bit.
Yes. So, I think that the assignment monitoring and modernizing that process is definitely an issue that, the Commission wants to revisit in the future since the bill didn't go this year. And you're right. I think the charter schools are unique. We all know that. And we heard a lot of concern expressed when we were in Assembly Ed Committee at our hearing, particularly from I'm blanking on it. Dr. Weber. Dr. Weber was very concerned that the sort of the uniqueness of charter schools, their ability to kind of innovate in their coursework and that sort of thing, that not be hampered by anything we're doing. And so that was balanced on the other side by folks who've said, charter schools need to be included in any monitoring process, and we would like them to be treated exactly the same way as public schools, and so we did try to strike a balance between those competing interests, and did try to do something in the bill that recognized the fact that charter schools are unique and that they are designed to be a little bit more innovative and experimental may not be the right word, but a little bit more experimental than traditional public schools. And so I think that if we do take another crack at this next year, the language that we had in this bill may not be perfect. We're going to continue those conversations with stakeholders, but that's kind of the mindset that we're going into it with, is trying to strike that balance and trying to respect the uniqueness of charter schools while still, understanding that every school needs to be accountable in some way. So.
Commissioners, any other questions or comments? Okay. No action is needed on this item. Thanks again, Mr. Speaks. This concludes the business before the Legislative Committee. The committee is adjourned.
And move to agenda item 2H, which is the report of the closed session agenda. And Commissioner Rodriguez is going to read that report.
Thank you, Chair Darlene Hammond. Staff briefed the Commission on the case of Kathleen Carroll v. CTC, and no reportable action was taken. Staff briefed the Commission on the case of Dr. John Doe, educator v. CTC. No reportable action was taken. The Commission granted the following petitions for reinstatement. First, Rochelle Hunter, Pamela Price, and Marie Thomas. The Commission denied the following petitions for reinstatement: David Acria, Victor Collins, and Billington Bolo. The Commission reviewed the transcripts in the matter of Emily Ismail. A decision and order will be prepared for the Commission's adoption. The Commission ordered a 30-day delay for preparation of the decision and order. The Commission reviewed the transcript in the matter of Mark Petrowski. A decision and order will be prepared for the Commission's adoption. The Commission ordered a 30-day delay for preparation of the decision and order. The Commission rejected the proposed decision in the matters of Andriana McCall and Hawanya Smith and called for the transcript. The Commission adopted the following proposed decisions: Eric Aval, Robert DeFrustio, Harry Kirshner, Lisa LaQuatra, Anna Ramirez, John Singh. The Commission denied the request for reconsideration in the matter of Leonard Eisenberg and sustained its previous decision. The Commission granted the request for reconsideration in the matter of Ofelia Quino and sustained its previous decision. The Commission granted the request for reconsideration in the matter of Kimberly Nickerson and remanded the matter back to the Committee of Credentials. The Commission discussed consent calendar item number 22, Damien DeLucchio, and 69, Deanna Quintano, and remanded the matters back to the Committee of Credentials. The Commission discussed consent calendar number 5, Timothy Bennett, and accepted the recommendation of the Committee of Credentials. And that is all. Chair Darlene Hammond.
All right, thank you. Next is agenda item 2I, report of the Executive Committee. The Executive Committee appointed Aya Shutt to serve as the Educator Preparation Student Liaison to the Commission for 1 year, beginning October 1st, 2018. And item 2J is new business. The bi-monthly agenda is presented for information. And I believe there's at least one audience presentation. So Danette Brown and Belen Moreno, please come forward. And if there are any other audience presentations, please put in a card so we will know that there are.
Good morning. Danette Brown, representing the California Teachers Association. And it's my great pleasure this morning to introduce our new Student CTA Liaison to the Commission. Belen.
Nice.
Hi, everyone. Good morning. My name is Belen Moreno. I am the new CTC liaison for the student CTA. And I'm so excited to be here. I am in a teaching credential program at UCLA. I completed my undergraduate degree at Occidental College, and this past summer I interned with public advocates. And so you can imagine how excited I was to work with Rigel Massaro, and I begged her to take me to the CTC meeting this summer. So I'm so honored to be here in this capacity, and I'm excited to be here now at every single CTC meeting. Thank you.
Welcome. That's wonderful. I guess we're a real hot ticket. And with that, I now adjourn the September 2018 meeting of the Commission on Teacher Credentialing, the meeting you want to attend. The next one is on November 29th and 30th, 2018. See you then.